couple things. We will have a hard stop at 7. I know Senator Patterson, Prince George's meeting 6. I'm just going to be missing it. Voting comes first. The other point I want to raise, and you probably heard the Senate President the other morning, yesterday morning maybe it was, talking about lowering expectations. We still have 50, 80 bills. I want to have a manageable list each voting session. At one point, he even suggested some committees should vote once a week instead of twice, but that's going to leave a hell of a lot of bills unaddressed. So we're still going to move forward. I'm trying to meet with committee council each week to address bills and decide what's on the list. It's never simple. It's never easy. Some bills that may likely die, whether they die by a vote or die by we don't get to it, that's going to happen. But we're going to have to make some judgments here, and I welcome your input. I know everyone has bills, and your 36 colleagues have bills. And I've already started to get swamped from other senators about why haven't you voted on a bill yet. As you know, we're trying to get there, but we want to have conversation on the bills that need the conversation. With that, we'll start at the top of the list, Senate Bill 22.
Senate Bill 22, on-site sewage disposal systems inspection licensing. This bill repeals the current law requirements related to the certification of those engaged in the business of property transfer inspections for on-site sewage disposal systems, and instead requires that by July 1st, 2022, any person, unless exempted, who engages in the business of inspecting a septic system must obtain an on-site wastewater property transfer inspection license issued by the Maryland Department of the Environment. There is an amendment in your packet on page 1 of the packet. It's amendment number 863626/1 from Senator Hester. The amendment alters the bill's penalty provisions to make each septic system that an individual inspects without a license a separate offense, rather than making each day a separate offense.
Okay. While we had the bill before us once, let's just move the bill in front of us. Is there a motion on the bill? It's been moved. Is there a second? It's been seconded. The amendment's been explained. Any objection to putting the amendment on the floor? I'm going to have her explain it, but is there any objection to moving it in front of us?
On the floor here. No.
Yes. I'm sorry. Moving it in front of us for a conversation. Senator Hester, you want to briefly explain?
So that all speak to the amendment. The first question was, how many inspections do you do in a day? And the answer was that an inspection company can perform inspection on the cheap. So basically they could get multiple fines in one day. What groups support the amendment? Clean Water Action, the septic industry, environmental health directors, and MACO. The amendment was requested by the environmental health directors as an affiliate of MACO. Question 3, has the MACO amendment been addressed? This is one of the amendments that MACO asked for. Question 4, if you do more than one inspection in a day, do you want them to get multiple fines? As it was first written, the fine would be set per day, but the health directors requested that it be per inspection. As per their requested amendment, the inspector performing multiple unlicensed inspections in a day would get multiple fines. Question 5. What amendments does Senator Young support? This one.
Senator Hester, Senator Carosi, you have a question or comment or debate?
Thank you, Senator Hester. That answered most of my questions, with the exception of in the MACO testimony, it said support with amendments, plural. And I think you said this amendment addresses one of theirs. So I didn't know if when they said support with amendments, and we have this one amendment, do we know if that's addressed Mako's concerns?
She can't speak for Mako, but if you want to offer other amendments, you're happy to. We know it addresses one of their concerns. Further discussion on the amendment? Anybody object to the amendment? Okay, the amendment's adopted. The bill as amended. Discussion. Senator Riley.
I don't believe the bill addresses the amount of the fee that can be charged for each inspection. Am I correct with that?
The amendment does not change it. So the law establishes a maximum penalty per.
Not penalty.
Well,
The amount of the fee charged by an inspector.
I'm sorry. I get you for the. No, it does not set it.
Okay. And Mr. Chairman, that's my big problem. Fewer inspections, law of supply and demand. We had some testimony that I think against the bill that these fees, instead of a couple $100, could be 2 or 3 times that level, and that's my concern. I'm not sure if this bill is ready because of those of that particular issue. I don't know if we want to dictate to private industry their maximum fees, but I'm inclined to resist a little bit. Thank you.
Just so I'm clear, you're talking about the fees the inspector can charge, not the administration in terms of. Okay, let me ask this. I mean, do we do that in other inspections? We do.
Mr. Chair, if you've had your car inspected at a repair or at an inspection station, there's a flat fee that's charged. There was also a fee bill that we handled, I think this session, but I can't recall the exact industry. But yes, it's not unheard of, it's unusual.
Thoughts, Senator Hester?
Could somebody just articulate where in the bill, what line we're talking about the fees?
I think the senator is saying, should we intervene and cap what they can charge the customers? It's not, yeah. I mean, you feel the bill is deficient. No, I understand that. I mean, clearly, the department promulgates regulations with getting certified or whatever it is. Obviously, in promulgating regulations, they could do something beyond that, or we can take a step, or we can be silent, or we can hold the bill. So I guess my question, it's up to the committee. I'm agnostic. We passed the bill last year out of the Senate. I think we've made some improvements this year. I'm trying to think besides car inspection, analogous situations.
More akin to a property.
I'm sorry.
This would be more akin to like a property inspection for a home inspection, because we're only talking about transfers or property transfer inspections, and I don't know whether home inspector fees are capped.
I think home inspectors or lead paint inspectors have an explicit cap in the law. Senator Riley.
I believe there's a cap for home appraisals. But in any event, again, unusual but not unheard of. I put it before the committee to see if there's any other reaction, good or bad.
Committee, we set the policy. What's your pleasure, Senator Washington?
I just think that's another bill, so it would be good to have a hearing on that. But so I would move favorable in the bill, and I appreciate what you're saying, but I think that's a separate bill. We haven't been asked to contemplate that issue. It's just been, we're asked to contemplate whether we're establishing a licensing. So that's my thought. It's a separate bill. It's not for us to add that.
Bills before you as amended. Senator, if you want to move to special order, see if you have 6 votes. Okay. And look, the other thing is we can have this conversation. The House can do some homework, and also they can make some adjustments if needed. Okay. Further discussion on the bill. Let's do a roll call as amended. Okay, next, please.
Senate Bill 34, State Board of Physicians, Genetic Counselors Licensing. This is a bill by Senator Lamb. The bill requires the Board of Physicians to license genetic counselors by October 1st, 2023. It establishes a scope of practice for genetic counselors. Certain groups are exempt from licensure requirements, and they are all listed within the bill. Licensure qualifications are established. Certification by a national certifying organization is one of those requirements for licensure. The Board of Physicians can waive certification requirements under the bill for licensure if an applicant has practiced genetic counseling for a minimum of 5 years and met other qualifications. The bill determines in general the license terms, expiration of license, licensure renewal, denial, and suspension of licenses. The bill establishes the Genetic Counseling Advisory Committee within the Board of Physicians, committee responsibilities, and membership terms of a committee member. As drafted, there will be 8 committee members. Maryland Right to Life submitted unfavorable testimony, and there are amendments that we processed through in the subcommittee. Board of Physicians and Senator Lamb discussed those, came to consensus based off of Board of Physicians testimony, kind of identifying some concerns. So there is consensus. And the amendments are separate from the voting packet, but there are 7 based off of consensus met in the Health Subcommittee. So these amendments are as I will explain. The First Amendment delays implementation of the bill. So as opposed to the October 1st, 2023 licensure mandated date, genetic counselors are now to be licensed by January 1st of 2024. The effective date of the bill is also pushed back to January 1st, 2021, as opposed to October 1st. We put a 5-person quorum on the committee. This changes the structure of the committee to 3 genetic counselors, 3 licensed physicians, and 1 consumer member. There's a waiver of a national certification requirement that in the original bill was listed as a requirement for qualification. So provisions are explained to waive national certification. Employment qualifications for licensure exemption for out-of-state candidates are also explained within the amendments. Disciplinary consequences are altered. So adds a disciplinary consequence for overutilization of healthcare services and removes a disciplinary consequence for another item listed. And the 12-month period of practice for recent graduates, which was permitted under the original bill, is removed, and now there are provisions for the licensure of supervised genetic counselors. So these supervised genetic counselors can hold a license so long as they are qualified. It establishes the expiration and licensure of those individuals as well.
Is that it? Okay, let me go to the subcommittee chair and vice chair.
So I'm going to move the bill favorably as amended, but in doing so, I just really want to give a shout out to the sponsor of the bill, Senator Lamb. for working so collaboratively with the Board of Physicians and helping us get to a kumbaya moment, and to Alexis Foxworth for her attention to details and support for the subcommittee on health occupations. So with that, I move the bill as amended.
Unless people, you can speak to the amendments or the bill at this point. Well, let's go to, I think I saw Senator Carosa first.
Thank you, Mr. Chair, and thank you to the work of the Health Subcommittee. Just to bring myself up to speed with all these different licensures that our committee does, can you, Bill's sponsor, Senator Lamb, Dr. Lamb, can you just explain, is basically what we're doing is we are now, we will be putting a license in place for these genetic counselors, and what are they required to do at this point? Are they certified now, and now they're going to be licensed? I'm just trying to understand if we're, classifying a new group and just taking them to the next level.
Pretty fair question, please.
So that's a good question. The purpose of the bill is because right now there is no licensure for genetic counselors. So they are essentially practicing kind of in an unlicensed status. And that's why they've come forward and said that they would like to be licensed, number one, so that not anyone can just hang up and shingle and say, I'm a genetic counselor and come and schedule appointments. But two, to also set up a level of standardization across the board for these genetic counselors, because then we can require them to meet these national standards and the board exams that they have to take by setting up this kind of a licensing mechanism for them. So right now there is nothing for genetic counselors. They can just hang up a shingle and say, I'm a genetic counselor. I passed one of these graduate degree courses, and call themselves a genetic counselor. So this would actually set up requirements in place.
And do you know just about how many? I know if we don't, because they're not licensed, we may not know that who's hanging their shingle up, but do we have roughly an idea of how many there may be in Maryland?
I think there's about 100 to 200 genetic counselors here in the state of Maryland. We have two programs, one at University of Maryland and one at Johns Hopkins, that trains genetic counselors in it's like graduate degree programs. And so one of the other concerns that we're hearing is that because they're not being able to be licensed here after they practice, oftentimes they will go to other states that actually have licensing schemes set up for them.
Okay, thank you.
Very much. To the bill sponsor, isn't one of the important issues about becoming licensed and certified and regulated that they're going to be able to be charging more under insurance billing?
So right now, they're not charging anything. They're really, the work that they're doing is being built into like a hospital or a whole visit fee that would go. This bill doesn't speak to the reimbursement mechanisms of this. I think that may be a future bill that the genetic counselors may want to look at some point in the future. But at least this lays the groundwork for them to have that conversation. But this really is focused just on setting a standardization and being able to, require that those who call themselves genetic counselors have some baseline knowledge and have met board exams and such.
I'm all for that standardization. And do you know if other states allow genetic counselors to bill as an insurance code?
I'm not sure.
Okay, we can look at that before I get to the floor. That's fine. I would like to have a clearer definition. Does this bill increase their scope of service? Are we changing what they're doing?
No, we're just sanctioning what they're doing as something that's a licensed practice.
Thank you, Doctor. Thank you, Dr. Senator. Senator, Doctor. Mr. Chairman, we got the letter of concern from the Right to Life. I understand that. Some of us are hypersensitive about certain issues. We get it. But we have to recognize that genetic testing covers an awful lot of issues. My daughter-in-law had a mother die at age 49 from breast cancer, and she went through genetic testing to see if she carries the gene, if she is susceptible, should she take proactive steps to protect her health. And I think that happens all throughout the medical field. I'm very supportive of this genetic testing in general. I just want to clarify that scope of service. Thank you, Mr. Chairman.
Seeing no further lights on, the bill as amended, will anybody be voting against it or objecting to it? If so, raise your hand. If not, we'll record it as unanimous and send it to the floor. Okay, next bill.
Senate Bill 84, Pharmacist Administration of Self-Administered Medications and Maintenance Injectable Medications. This is another bill that we handled in subcommittee. This is sponsored by Senator Young and Senator Waldstreicher. The bill expands the practice of pharmacy to administer maintenance injectable medications, permits a pharmacist to administer a maintenance injectable medication that is not a biological product, so long as 3 requirements are met. It's prescribed by an authorized prescriber and complies with the standing order of authorized public health officials, and it's in accordance with protocols regarding a therapy management contract. The bill requires the Board of Nursing, the Board of Physicians, and the Board of Pharmacy to adopt regulations that establish procedures for administration, including procedures to be used after an initial dose is administered. And these regulations have to be adopted by September 1st, 2022. The required regulations under the bill must mandate a pharmacist to undergo a training program, to follow standard procedures, to notify the prescriber, and to meet certain record-keeping requirements after administering a maintenance injectable medication. The bill also has insurance requirements. So under the bill, private insurance policies and state-based Medicaid programs are required to cover these services, provide reimbursement to the same extent as they provide reimbursement for the same administration of services when they are provided by other health practitioners. The Board of Nursing did oppose this bill. There are several amendments that were adopted favorably out of subcommittee. So the first 2 included in the first pages of your voting packet are 2 technical amendments from the sponsor, and these were solely to match the House file of the bill. And I can get those numbers, but we can just keep following along. The amendment that starts with 573-822 is an amendment sponsored by Senator Lamb, which would include the treatment of a sexually transmitted infection to the scope of permissible purposes for administration of maintenance injectable medication. And finally, there were additional amendments that we adopted out of subcommittee that were requested by the Office of the Attorney General, and these deal with notice requirements and consumer protections. And so essentially, let me get the number for those. So this is 214235 under the SB 84. So the amendment would prohibit a pharmacist from administering an injection, without providing notice through the form that is provided. So the form is included in the amendment, and the form must include notice that the pharmacist charges a fee for administration separate from the cost of the medication if they do so charge. The fee amount, notice that the patient may have to cover the balance of the fee if insurance does not cover it. The form has 3 options that must be checked, where applicable. So whether a benefit plan covers the fee, whether the plan does not cover the fee, whether the pharmacist has a contract with the patient's plan or does not have a contract with the patient's plan. Payment that is required and signed acknowledgement of consent is also required. So it requires notice to be given when a pharmacist charges the fee for out-of-pocket cost, and a signed copy of the notice has also needs to be given to the patient. So that covers all 3 amendments that were adopted out of Health Subcommittee.
Let me go to the subcommittee chair, Madam Vice Chair.
Again, to Ms. Foxworth and the excellent members on the Health Occupation Subcommittee. I also want to give a shout out to the Office of the Attorney General for looking out for consumers in their Consumer Protection Division. With that, I will move the bill favorably as amended. Thank you very much.
Discussion, Senator Carrozza.
Thank you, Madam Vice Chair. I'm just trying to follow if the amendments, once they were adopted in subcommittee, if we then went back to the groups that were supporting it to make sure they were okay with the amendments, given that I think one of the amendments that Senator Lamb offered might affect what pharmacists can and can't do, and I just want to make sure that amendment is not a surprise. And also, I did not hear if the amendments that were suggested by the Maryland Insurance Administration were adopted.
Somebody want to take a cut at that?
So amendments from Maryland Insurance Association were not adopted. And in terms of, I guess, assent to the bills, I haven't heard contrary evidence. The individuals from the Office of the Attorney General were on the call when we discussed the latter two amendments, and I haven't heard anything in opposition to those.
Yeah, Senator, let me give a response, and I don't mean to be curt. The committee sets policy, and some of the testimony was listened to, and some resonates and some doesn't at the hearing or subsequent to the hearing. But the committee doesn't have any responsibility to check with the people who like it or don't like it to see if they're happy, because we wouldn't do anything, get anything done. And again, being sympathetic and having someone move an amendment because they believe in it is totally appropriate. And if there's one that was raised that you feel strongly about, the floor is open for you to raise it. But I think it's a heavy duty to have either subcommittee or council on every bill go back to people who either liked or didn't like to check to see if it's okay.
No, I understand that, Mr. Chair. I think the question is, we've had in this committee, we have different constituencies that sometimes go back and forth, whether it's scope of services or other issues, and we've had issues between the pharmacists and the physicians, and so I was just trying to, again, make sure there were no surprises, that in an effort to amend the bill, that we also didn't, that the original supporters backed away. I would think maybe we would have heard, but so that's why I asked the question. I'm not in a position to offer an amendment because I don't have that information.
Madam Vice Chair.
Thank you. If I can just add on, Senator Carrozza, that our meetings were live streamed and publicized, and so there were interested parties that did participate and join in and offer their insights, and others I had certainly had the opportunity to observe and email. So for whatever that's worth, and so they do have representation here. And there are also two more steps, which is second reader on the floor as well, and where it can be amended, and third reader debate. So for what that's worth, thank you.
Thank you.
When there is a subcommittee meeting, council usually goes through the people who testified and lets them know there was a subcommittee meeting. And if they feel they're being done wrong, they will probably seek out one of us to address the issue where they feel they've been done wrong. So, we can only do so much, that's all. But I appreciate your question. Senator Lamb.
Sure. So on the amendments that I offered on the bill, the pharmacists are okay with it, as are the nurses, and the sponsors also okay with it. So just to answer your question there.
Okay. The bill as it came out of subcommittee, bill as amended, further discussion. Will anybody be voting against it? We'll save a little time. If not, it'll be recorded as unanimous. Next bill.
Okay. So Senate Bill 121, Zoning Environmental Justice Considerations. This bill requires a local governing body to require the preparation of an environmental justice analysis as specified upon an initial application for a special exception to construct or operate a landfill in an area zoned for residential use, or upon an application to extend or renew such a special exception. The environmental justice analysis is to be prepared at the expense of the property owner. The bill also requires the Commission on Environmental Justice and Sustainable Communities to issue a report by December 1st, 2021, making recommendations regarding strategies for increasing state oversight of and involvement in local zoning decisions that present environmental justice concerns. I am going to send around another amendment. So we'll start with the amendment that's in your voting packet on page 11. This is amendment number 393720/1 from Senator Patterson.
Madam Counsel, is this in addition to or replacement?
In addition to.
Okay.
So the one on page 11 of your voting packet alters the language concerning the study undertaken by the Commission on Environmental Justice to say that the study should focus on supporting local governments and communities in environmental justice concerns. So that's the amendment in your voting packet. Oh, sorry about that.
I'll get mine.
The amendment that just came around is also being offered by Senator Patterson. This amendment strikes the language having to do with the environmental justice analysis requirement for zoning considerations, and instead requires certain facilities that are listed on page 2 of the amendment. Upon application by those facilities for a new permit or the extension or renewal of an existing permit issued by the Department of the Environment, it would require the department to require those facilities to prepare, at the applicant's expense, an environmental impact assessment, health impact assessment, and projective environmental analysis in coordination with the department and the Commission on Environmental Justice. Additionally, the department would be required to provide a meaningful opportunity for the public to provide input on all permit applications, including applications for permit extensions and renewals received from the listed facilities, and to make assessments and analyses prepared under the bill public, including by placing them on the department's website. The department would further be authorized to impose any conditions on the permit necessary to mitigate environmental or health impacts on nearby residential communities, including restrictions on operating hours. Finally, the department would be required to require a facility listed in the bill to annually certify to the department that the facility is in compliance with all permit requirements, including the conditions imposed by the department, and conduct at least one in-person inspection of each facility every year. Finally, the amendment would authorize the department or any person or unit of local government to bring a civil action to enforce compliance by a facility with the requirements or conditions of a permit issued by the department. There's one final amendment to this being offered to this bill on page 12 of the voting packet. This is amendment number 404530/1 being offered by Senator Pinsky. The amendment would apply the bill to any facility for which certain environmental permits are required, remove the language specifying the contents of environmental justice analyses, and instead authorize but not require a local zoning authority to require the preparation of a health and environmental analysis for permitted facilities. It would also add language specifically authorizing the zoning authority to deny an application or place conditions on the approval of an application that raises environmental or health concerns. Finally, Senator Pinsky's amendment in terms of the study for the Commission on Environmental Justice would include the language being offered by Senator Patterson on supporting rather than providing oversight of local zoning decisions, but would also add additional language requiring the Commission to make specific recommendations regarding options and strategies, including the identification of model ordinances for incorporating environmental justice concerns into local land use and zoning decisions.
First, we have to put a bill before us before we get to the amendments. Does someone? Okay, it's been moved and seconded. I'm going to start with the sponsor of the bill.
I was under the impression that we were going with your amendments sort of were a substitute for my first set amendment. Am I not right here? Are they all? Okay, we're all right.
Much. So the first question is, with these 11, is this amendment going to be coming in with the 11 delineated?
Yeah, that's what I was under.
Look, there are three sets of amendments, going from softer to harder, if I can put it that way. Senator Patterson, you're the sponsor. I'm going to give you, which one do you want to start with?
In terms of the amendments? Yes, because I think it's sort of overlapping here a little bit. So I think if we go ahead and adopt your amendments, that may well take care of the amendments that I was going to propose, and we may not need my set amendment, provided we can insert your amendment with my amendment number 1 and 2. Second.
That is on page 12. And let me take a second, and then I'll call on you, Senator.
Yeah.
Having the state take over zoning authority from the 24 counties, I think is very dicey. And we're going to get pushback from 24 county executives and 24 county councils. That doesn't mean we should allow them to run roughshod and not do what needs to be done to protect people. And I don't know how uneven or even each jurisdiction is in reviewing permits or extension of permits. So what my amendment does, instead of having it just landfills, it says any permitted facility. It's more of a general umbrella. Then the other thing, which I think is the most relevant, is that it says a local body may require the preparation of an environmental impact statement to be paid by the applicant. They may. It doesn't require them to. And also, they may deny the condition of approval on the application based on the environmental conditions and health impacts. Now, some would say local jurisdictions can do that now. I've heard mixed things, that some feel they can't unless it's explicitly authorized. So what I've tried to do here is authorize that they can do it, and it's a defensible action. So in other words, if they think it's a danger, they can call for the environmental impact, and if they want to reject it on those terms, they have legal grounds to do it. Now, maybe some will say it's duplicative of the practice, but it tries to put it in statute that we think these are important and these are grounds for doing those certain things. At the end of my amendment talks about working collaboratively between the MDE and local governments, and is very similar to the language of Senator Patterson's. So I was just trying to bridge and come up with an answer, a possible solution. It may or may not be the right one. Senator Patterson.
Yes, yeah. I talk with staff people at Department of Environment, and they were concerned too about the zoning and the special exception and the oversight language. So what's in Devin Dobson over there? And so I removed, that's one reason why I put Amendment 1 and 2 to take that all out. Is the bill what I like for it to be? No. But there's another day, and, perhaps we can continue to work during the recess or the interim and see if perhaps there might be something else we can do another day, another time.
on Senator Riley, but just for clarification, Senator Patterson, we were just given another set of amendments that requires environmental impact statements and civil action. Is it your intent, and again, you can do whatever you want to do, to move this after we possibly adopt my amendment, or are you going to drop this?
No, I want to move it out to adopt your amendment.
Okay. Senator Riley.
Okay, thank you very much, Mr. Chairman. I don't think the nuance of going from permitted facilities to the delineated list under Senator Patterson's now defunct amendment matters too much. I think all of those 11 things are permitted facilities.
That's not the defunct one. He was talking about the one on page 11. He had a very short one on page 11.
Right, that's fine.
I have one on page 12 and 13, and he has a new one freestanding.
Okay,
So right now, we're amending the bill.
right.
So this, his newest amendment is not before us quite yet.
That's fine. But in your amendment, you have landfills and substitute permitted facilities.
No. I take out landfills, don't I?
Yeah, you took out landfills
Right,
and substituted permitted facilities.
right.
And my question is, isn't that list that was on the prior packet, all the permitted facilities, aren't all 11 of those projects permitted facilities? Because they all have to come in for a permit.
If they are, I don't care how we word it.
Okay, that's fine.
Okay.
And the general question is, do we know the number of applications per year that will be submitted to the Commission for Environmental Justice and Sustainable Communities? Each one will have to be submitted to them for review, correct?
No, that's in the, as I understand it, that's in Amendment 3, which is not before us.
Okay,
In other words, his first one, he's withdrawing.
Right.
In deference to, I think, the one I'm suggesting.
right.
That would either pass or fail, then he plans on moving his newest amendment, which, and I'm not saying this pejorative, is a lot more extensive. That's all.
Yeah.
So,
All right. There's still a report required on page 18 of our packet. On or before December 1st, 2021, Commission shall report its findings. Page 5 of 6 in the bill, page 18 at the bottom of your handwritten.
Yeah, so the Pinsky amendment, the original bill did two things. It has the zoning, review provision. It's mandatory. The original bill, it's mandatory. Senator Pinsky's makes the environmental impact analysis discretionary.
Right.
Both of them included requiring the Commission on Environmental Justice to sort of look more broadly at how environmental justice considerations are considered or should be considered at the
Excellent.
local level.
Excellent.
Senator Pinsky's amendment, it's in response mostly to MML's concerns about the original language, making it sound like we're going to do state oversight. So it instead says, how can the state support and work with local governments, but then adds an additional language sort of directing the commission more specifically to sort of come up with specific options that local governments that are interested
Right.
in incorporating this more into their work
Great program.
to do.
My question is the date.
Oh, okay.
I understand the purpose, and I like it. The question is, on line 22, it says on or before December 1st. Is that still in?
Yes, it has not changed.
I'd recommend, I got a note that said they want to push back, they don't think they can make it. I'm going to suggest we amend that to June 31st, 2022, 6 months. The report goes to the governor. We don't have to be here. I don't want to push it back a year, but I think 6 months is reasonable. Okay.
amendment.
Thank you,
Anybody
Mr. Chairman.
else? Anybody,
Can you repeat the date?
He wants to make it 22.
On the bill, page 5 of 6, line 22, change December 1st, 2021 to June 31st, 2022.
well, let's make it June 1st,
June 1st.
That'll be a full
That's fine.
6 months.
That's fine, June 1st.
June 1st, 22.
Yeah. Any
That's fine.
objection to the amendment to the amendment? Okay. So we have the amendment. Okay. That amendment is adopted, so the Pinsky amendment's in front of you. Senator Patterson, you want to speak to it?
No, okay, move favorable.
Senator Simon Ayer?
Thank you. And I've sat next to my colleague for several years, and he's brought this similar bill back many times because he's have concern in his district. So my question is, on this amendment, is this really going to do anything for your situation? Because I'm assuming the county could do it anyway, but let's just assume they can't. I'm also assuming the county probably wants to keep the landfills, because if they don't, then they have to find another place, which is probably a bigger problem.
Yeah, then it'll be in my backyard.
Right. So by just granting them a May, are we really moving the ball forward? I mean, it sounds good we have a piece of legislation here, but
Yeah.
are we really doing anything?
Let me call him the sponsor.
As I said earlier, it's not what I would have liked. But given all the power brokers in the state and the folks you have to go up before, to get even this far is a little progress. Now, we are basically hurting in my district. I think I sent you guys a 2 or 3 page letter. You know, this guy has been there, came in 89. He had 40 acres up to 170 acres now. Has gotten 3 special exceptions that equal to 15 years in addition to the expiration date. And we haven't had as much one evaluation determination. So, you know, people's lives are at stake here, and this is just bad. And it's not because we have not been trying. I mean, we've gone as far as the circuit court, but I don't need to tell this committee. These type of businesses are well connected, and it's hard to mount a very strong, effective mechanics to get justice. But you know, I happen to have had someone from Annapolis who came out to my district to take a look at it the last 2 weeks or so. And I said, well, you know, why are they always in black and brown? She said, well, it's not just hearsay. Even the one in Annapolis is right in the midst of a black community. So, you know, it's at the point that do we help save people now, or do we sit around and let people die? And that's why the bill is before us.
Senator, if I could, to your question, if I can add, look, so far the county council, as sitting as a zoning authority, has not been responsive. That leaves us 2 choices. We can set a statewide bill where we intervene in local zoning, or the other option, which I shared with the senator last night, was maybe not this year, but next year, put in a local bill that asserted the look, my amendment doesn't solve this problem, but I'm hoping it moves the ball a little bit. Maybe it doesn't, and if it doesn't, we can just kill it. Okay. Sure.
But, I mean, from what I'm hearing, though, is you're saying the county council is not going to do anything. So it hasn't so far. So the state coming in and say you may do it is no real hammers, not even a little pick. So, you know, I don't know if we can make it a local bill and just put the hammer in there.
Speak to that, Mr. Chair. I think at this point I would suggest we move forward with what we got, and that will not eliminate me from coming back next year or 10 years down the road and continue fighting for justice for those folks that live down in my district. So I would say let's move the Pinsky Amendment and live to fight another day.
We'll move forward, but I want to ask committee counsel, because I had a discussion when I asked this to be drafted. whether we knew if any county councils were requiring environmental impacts, particularly as it affects cumulative hazard to minority communities, and whether they felt they could do it if they wanted or reject a project based on those issues. And I think the answer, well, I don't want to speak for you.
In doing, and I don't know the answer specific to Maryland, but there has been a lot of policy more broadly written about zoning boards feeling like they do not have the authority to require any sort of environmental review or to reject or condition a project based off of environmental or health hazards. Now, I don't know whether that's because they haven't adopted, local ordinances at the local level that are allowing those sorts of reviews to take place, or whether that's because they feel more broadly that that's not a part of sort of the zoning analysis that they should be doing.
Thank you, Chairman. Also, thank Senator Patterson for bringing this bill. The expanded permitted facilities, while it originated as a local concern, for me, it provided an opportunity of a concern because I had a concern about a crematorium. And why I think that passing this bill with this language, there is some, as you said, locally, if something is a state sort of permitted license, what role, what role does the local have in requiring the state or requiring that there be impacts based on their local concerns? And so, again, it started out with you, but this permitted facility option, I think, expands the opportunity to allow local communities to raise these concerns. And it just, I think it's going to empower some local folks. And if we make sure that with some of the language in the Second Amendment that it's about, at least from the state agency, requiring that there is some connection with the surrounding community and notification with the community, because there are several times when these facilities are permitted in our neighborhoods, the community say they didn't hear anything about it until there was construction. So I think we can actually, this will be making a step forward. So I support the amendments, and I look forward to, moving the additional amendments. Thank you, Chairman.
I'm sorry, Senator Hester.
I was just trying to figure out, can we have it be a statewide bill, but then add something specifically about this local instance?
I guess we can do anything we want, but it'll be met with major resistance on the floor.
I see. Okay. Thank you very much.
He has another amendment, so the Pinsky amendment. Any objection to adopt? I'm sorry.
All right, no problem. So I've heard his concern over the years, and I'm sympathetic to it, and I want to help him. Other jurisdictions may not have this problem, and I could see that they could target certain people, businesses, whatever, by saying you have to have this, and it actually, where it's working well, this could actually put a wrench in the other jurisdictions that don't need this. That's why I'm really a big proponent of, the problem has come out year after year after year because of a district that he's in, and it really sounds like a local issue that they should deal with. I haven't heard any other jurisdictions raising this issue, or at least there's a lot that haven't raised it, and I'm just concerned that what we mean for good for his district may upheave other ones. So that's my concern with doing it that way.
Speak to that. I think I indicated a few minutes ago that it's the same situation right here in Annapolis. They're concerned about the pollutants from the cars, so many trucks coming in, and I don't think most folks understand the impact of this kind of facility in your neighborhood. We stood out there about 2 weeks ago, and for 15 minutes, at least 25 trucks came through. And again, I was joined by a reporter, a white reporter, who lives in Annapolis, and she said, yes, the one in Annapolis is the same. And I know down in Brandywine, they had power plant, and they went as far as to go in the court, and DER and EPA and other groups got together, and they came up with a solution to the problem. So it's not just strictly in my district. It's mine today, but I can assure you down the road it's going to be probably others as well. And I know at least 3 that are experiencing similar type problem.
Amendment, the Pinsky Amendment, all those in favor of adopting the Pinsky Amendment, raise your hand. Opposed? Okay, the amendment's adopted. Senator, now you have another set. Do you want to pursue them or not? I don't.
No, I just want to go with the Pinsky Amendment.
Okay, so then, okay. Then we have the bill as amended. Discussion? Seeing none, do we need a roll call? I mean, if people want to vote, you know. Okay, roll call.
Uh, 30 years ago in my home county, they tried to put a trash dump in a mostly African-American community. And it launched the career of a lot of local elected officials because they rose up and in an election in 1990 changed a bunch of county council members out, and through local zoning and laws they were able to get that thing stopped. You saw, so my feeling is each county that has this issue, they should be working at the county level. I'm sympathetic to the issue because that was in my community. It was neighbors of mine almost that would have been affected. So I'm going to vote no, but I want you to know that I am sympathetic and think this should be done at the county level.
I don't think sympathetic votes count, but go ahead.
Yes.
Okay, the vote is 9-2. The bill passes as amended. Senate Bill 127.
Senate Bill 127, Institutions of Higher Education, Use of Criminal History and Admission Modifications. This bill prohibits an institution of higher education that receives state funds from disqualifying an applicant from undergraduate admission based on the applicant's criminal history obtained from a third-party admissions application. Further, an institution may not make inquiries into and consider information about a student's criminal history for the purpose of admission, including to deny or limit a student's admission into a particular academic program. Lastly, an institution may not automatically or unreasonably restrict a student's access to campus residency based on the student's criminal history. There is one amendment offered by Senator Pinsky. It's separate from your voting packet. I put it on everybody's desk. It has STAG at the top of it. You'll recognize that. And what this amendment does is authorizes an institution to develop a process for determining or restricting access to campus residency for students convicted of sex crimes.
Move the bill first. It's been moved and seconded. This deals, as was just said, with common applications and check in the box. It can't be used to deny admission. It refers to it can be considered under residency. I just wanted to be very clear, and maybe this is not the right verbiage, because I did it just about an hour ago, where I had it was suggested to me from someone outside of our committee. And this would be, where would this, Stacy, what line would this?
Two.
Oh, I'm sorry.
16?
So, look, the point here, someone steals a car when they're 15, that shouldn't restrict them from living in a dormitory. They do their time, they should be able to get into the college, they should be able to be in the dorm. Part of the process should be whether it was are some people going to be concerned if it was a sex crime? It just has to be considered when they review it. That's my amendment. Again, Senator, things have been pretty busy today. I didn't get back to you on this. Let me go to Senator Gallion first.
I wanted to speak on the whole bill. I think you have an amendment. You said, I think I'll wait. I just want to speak on the bill as a whole because I did have like, if you allowed, I could talk briefly about it now and see how your amendment addresses it. But during the hearing, I brought up concerns if you had somebody in high school that did some kind of sexual assault or something like that on somebody, and then that couldn't be brought into the conversation when they're going to go to college. I'm really sympathetic to victims, and a lot of folks, turn a corner. They had a great panelist on this hearing that had a great story how he turned a corner after committing, I forget what his offense was, but it wasn't a sexual crime in nature. So I just have real concern about opening up down a path where someone does that kind of crime and then they can go on this campus and potentially, it's our sons and daughters that are on these campuses that could be negatively affected. I mean, a lot of folks turn the corner, but some honestly don't. There's a pattern there. So that's a major, major concern for me.
Moved and seconded. Okay. Yes, Stacy.
Before we get to that, may I speak to Senator Gallion's concern? I just wanted to make the committee aware that the existing law, as it is now, says an institution can't develop their own application that asks for criminal history of a student. That information can only ask for later. So what this bill does is it moves to institutions that use the third-party applications that have that question on it, and they were exempted from that provision of law that was passed a few years ago. So this just brings them into alignment with the existing policy and says that this criminal history can only be used for a very specific purpose at a very specific time, just to speak to your concern.
To be clear then, if you didn't like that law from a couple years ago, you're probably going to like this one either.
Exactly right.
Okay.
Thanks, Lamaria. Sorry. Stacy, thank you for referencing that. That was exactly my question because I remembered that we had taken action on this. So this is just basically bringing it to compliance if you do the national app. Okay. And just one more question. Are you aware of any data or even any anecdotes of problems with criminals coming in and causing mayhem or something in a dorm?
I am not aware of any information.
Okay. All right. So there may not be a problem that we have to worry about, that if it's working already in Maryland, we just want to make the national, our participation there compliant.
I can't speak to that.
Sure.
So.
Sorry. That was unfair. Okay. Thank you, Stacy.
Thank you very much. As Senator Gallion said, this is not a new issue. And when it came up last time, I'm not even sure if I was on the committee, but what I did do was I called the president of my local community college. Dr. Lindsay is a well-respected, conservative-leaning type of person. She runs one of the best community colleges in the nation here in Anne Arundel County. And she said to me, Ed, this is an open campus. We admit everybody. If we had housing, we'd be concerned and we'd take action. But she found in her 30 years of being a administrator, no problems. When you have people, especially young people, you have problems. But these are not the problems that she found insurmountable. If someone is acting inappropriately, there are stalking laws, there is a campus security, there is a lot of other things that can be done. But based on her advice, I'll be voting in favor of this bill.
Thank you. So, I mean, I remember some of this, I think I came in late, compelling testimony. And I didn't support the first one, but this is a third party trying to get it back so it's even. But I believe that this bill goes further than that. That's not the only thing it does. And maybe Stacy could give me the scope of this, if it just applies to the third party or if this applies to all universities. In section 26504, it's removing omission on line 10 and line 16, and then later in line 18 and so forth. So before, I believe what it was saying is you can't automatically say just because they checked the box at a criminal record that we can't let them come in. But you can look into what they did, and that could affect whether we let them in or not. But it appears that this language is striking that they can't even look into it for admission. Is that true? I'm asking legal counsel.
So it does remove that provision in line 10. So previously it says that they may make inquiries and consider information about the student's criminal history for the purpose of making decisions regarding admission and access to campus residency, and it removes that provision about admission.
So the whole argument before was we don't want to just knock these people out because they had a criminal record, and it was just happening automatically. But we wanted to let the universities be able to say, okay, well, let me look and see. Okay, maybe it was just a carjacking when he was 15. That's not a big deal. We'll let him in. And then later on line 14 through 16 in current law, it also says that you can't automatically reject them for that. So that protection's already in there, but this bill is removing that. So it's more than just opening it up to a third party. I mean, I think this is another big alteration for all higher ed.
Yeah, but I think that's the current policy for individual applications from specific schools. I think they cannot use criminal history to deny you admission. And I think this is just doing the same thing for third-party applications. We can't require them to remove that question, but when it comes into the university, they cannot deny simply on they did something in the past and they put their time in. I don't think it expands it anymore.
If you look at page 1, in lines 19 through 21, it says an institution of higher education may not use admissions application that contains questions about criminal history of the applicant. So those university developed applications, they don't have access to that information and therefore wouldn't be able to use it in the process of determining admission. So the only people who have access are these third party applicants who get the information. And so this is, again, bringing them into the same posture as those other institutions.
So much last time. I get the argument that we shouldn't let people just be automatically rejected because they did something. But we're basically saying, you're saying this is current law, that the higher education institution can't investigate what type of crime.
They can't even ask the question. So in other words, if College Park has their own application, they cannot ask whether you've been convicted of a crime. So if they don't even ask that question, there's no way they can even investigate anything. And again, you might not have liked that original bill a few years ago. This is just trying to bring some symmetry to what's called the Common App, but the fact is, actually, the question's still on it. And we're setting a law saying you can't use it to deny admission. They are, for the third-party app, they're actually going to have an answer to that question. But right now, for the institutions that put out their own application, they don't even know. That was the policy of the legislature, I don't know, 4 years ago, 5 years ago. Senator Gallion.
So just to piggyback what Senator Riley mentioned about the community college, I'm a big supporter of the community college as well. I have 2 in my district. I was looking on page 2, so line 16, it also adds in about campus residency. So community colleges aren't, I mean, none that I know of are having people actually residency there, right? That's more for the bigger schools. So this would have, it really wouldn't have, that part wouldn't affect the community college at all, correct? Okay.
We're on the Pinsky Amendment, which adds that paragraph, making it clear that they have part of their policy for residents must include developing something having to do with people who have had sexual crimes. All those in favor of adopting the amendment signify by saying aye. Aye. Opposed, nay. Okay, the bill as amended. Yeah, the bill's up for debate.
Is that amendment you just said, is that in here?
It says stag at the top. It adds a paragraph, and there's a reprint following it.
Okay. So just following up on that last conversation. They're not going to know any criminal history, so how is this going to play? How are they going to know that they had a sexual crime?
On the third party, Maryland cannot require them to take the question off the third party app because it's national. So those that use the common application, that question will be on there. They cannot use it to reject a student based on that. But if they have knowledge and the person's going to be on campus, they can pursue it and get a better understanding of what the crime was.
So, and I support that, but aren't we creating 2 standards for non-third party applicants and this?
Thank you. Since I just had my granddaughter go to Salisbury in September, she had to fill out a separate housing contract that asked the question.
That was part of the bill from 4 years ago. Is that right, Stacy?
It's on page 2 in line 7. That's not
Thank you, Ms.
restricted to institutions with third-party apps. That says any institution may make inquiries into and consider information about. So at that point, you didn't have it on the application to get there, but as Senator Riley said, on the housing forms, they follow up. Maybe they have a criminal history question there, then they get access to the information, and then it can be used in consideration for access to housing.
Amended, further discussion? Let's do a roll call. The vote is 7-3-1. The bill passes as amended to the floor. Okay, next is 414, but before we start into that bill, I want to make a couple of announcements. 2 bills are going to go to subcommittee. The mold bill, which I believe is 70? Is that Senator Patterson or Ellis? Yes. Senator Patterson's bill is going to go to the environmental subcommittee to work on that, see if we can put it in some fashion that is workable and moves the needle. And then the FAFSA bill, that's Senator Ellis, that's going to go to the education subcommittee. I know the House is working on it, and we have to consider some amendments. We don't have to. We can adopt it like it is, but I think we want to hear from the multiple parties on that. I would also mention to the committee, we have 14 to 19 bills on procurement. We heard some, 10 or 11 today, and a week and a half ago we heard 8 or 10. It's a lot of bills. They're very complicated. So I haven't figured out how we deal with them yet. I'm open to suggestions. That's number one. We have a number of bills dealing with school mandates. Teach this, train this, whatever. There are probably 4 to 8 bills in that category. I would like to take them all at once. And then finally, we've had all the compact bills. We had plenty yesterday, and we had 2 or 3 before then. So I'd like to take them together too. So I'm not sitting on them. I'm just trying to figure out, taking them all together so we have a perspective and a philosophy, because if we do one, they may be unique or they may be common, and we sort of have to have some methodology in how we address these. Oh, and I didn't mention that because they've already started meeting. We have the cyber work group has met once. They're going to meet again and hopefully come back to us with some recommendations in the next week or two. Okay, let's go to 414.
Just, thank you for that update on breaking down. I was having the same reaction when the batch of procurement bills came through today. And I see how they're being broken down in different areas, whether it's procurement or the compacts. I just do want to point out that obviously as we go through those, I hope we would factor in some compacts are further along than others on the work that's been done, and some of those bills, like mine, had no opposition and have been worked on for a couple years. So I just don't want some of the bills that are further along and that have been worked on in the interim to be bogged down with some of the bills that may not be in that posture.
And clearly, they're all in our palm of our hands, so the committee can move some and not move others. They can do whatever. There are some common questions that have come up in almost every hearing about if a state certifies someone in their state and it's a different standard than in Maryland. So, I mean, there's some common questions that I think may need to be discussed. But you're absolutely right. Some are further along. We've already approved a few in previous years. Higher education is one. So we will figure out a way to address these and have a free-willing conversation.
Thank you, Mr. Chair.
Okay. On the climate change bill, I have a number of amendments. I'd like to start with those, and I know there are amendments from at least 5 or 6 different people as well. We'll take them one at a time. But I've already been dealing with a number of interest groups, and some compromises have been met already, so I'd like to do those first. Yeah, I also want to thank April for putting the timeline together. Hopefully everyone received that. We're very pleased to have all of our staff.
Okay. Senate Bill 414, Climate Solutions Now Act of 2021. This bill makes broad changes to the state's approach to reducing statewide greenhouse gas emissions and addressing climate change. I'm going to go ahead.
I've got 2 with 2 different timestamps.
Which one are we working from?
So one of those was probably one that was already sitting on your desk. So we're working from the one that says 216 on it at the top.
216, but one's at 355 and one's 404.
Yes.
The 355 is your amendments. Okay. The one, so that's all the strikeouts. The
404 is his amendment, basically.
Correct, yeah. So the 404, these are the amendments that we're about to walk through.
Put your mic on, please, Senator.
Hold on a second.
Yep.
So I'm looking through the amendments, and I submitted some. I don't see some for me. Is that?
So I have them here. was going to
Okay.
distribute them when we get to them,
Okay,
just because
thank you.
everybody's got a lot on their desk right now.
See, we don't have the amendment you suggested to her pointed out. I mean, I don't know if we're going to finish today or not. I think it's unlikely. So I think
But
she
it's
wants to
there.
do a section by section.
Okay, great, thank you.
I have them.
Senator Gallion.
You mentioned like 404 and these different numbers. I just want to make sure I'm looking at the same sheet of music as everybody else. Could you tell me what packet or where are we on right now?
So Senator Pinsky's amendments themselves are on page 20 of the voting packet, but
Is
the
that-
reprint, because it's so large, is separate. And it's the one that says, so it says, as amended by 454336-1,
Okay,
and then the timestamp on it is 4:04 p.m.
gotcha.
There you are. Now I am talking code here.
Then there's a single sheet that was just handed out, which is another amendment. And then there's a thicker reprint dated time 3:55, which I believe is Senator Simoneau's amendments. And then we have plenty of others after that. Okay.
Okay. So Senator Pinsky's amendments, again, they appear on page 20 of the voting packet, but the reprint is what is easiest to follow along.
Let's put the bill on the floor first, the bill unamended. It's been moved. Is there a second? Seconded. Okay, the bill's in front of us. We might break this up in terms of voting on amendments, so it's not throwing 20 at you at the same time. Ms. Morton.
All right, so amendment number 1 is technical, so we can skip that one for now. Amendment number 2, which is on page 16 of the reprint, alters the prohibition on using carbon capture and storage technology in the state's greenhouse gas reduction plan to say that such technology may not be used unless it has been scientifically proven to achieve verifiable carbon reductions.
Let me explain it. Originally, the bill would not allow carbon capture to be used in counting carbon reduction. There hasn't been a whole lot of proven technology to date, but technology changes. And I can tell you there were a couple of unions that thought that was inappropriate, that we had to be open to other carbon capture strategies. So I am moving the amendment on line 8. If it's been proven scientifically to achieve the carbon reduction, so be it. You know, I don't want to have language that says clean coal, for example. Yes, Senator.
And I will, as we go through the amendments, I have an amendment that completely strikes these 2 lines, and I can talk about them later on when it comes up. But it says, unless the technology has been scientifically proven to achieve these reductions. So who is the scientist that is saying this is proven or not proven? I mean, how do we, I'm just looking for some clarification on that line. It says, has been scientifically proven. Proven by whom?
My first goal in this language was to reverse my position of saying you can't use carbon capture at all. So I'm saying, look, if 2 years from now, 5 years from now, there's technology, it can be counted. I didn't, I thought that would be micromanaging. I mean, we can say the department, I don't have any scientists in mind. We can say verifiable by the MDE for that matter. I don't care. I just wanted to make it clear that I'm not ruling it out for now or in the future. That's all. So if you want to amend the amendment, you can, Senator. To be counted, puts it back in the bill, page 16, line 8 or 9. All those that would adopt that amendment, say aye. Aye. Opposed, nay. Okay, and again, we'll come back to your amendment, Senator. None of this precludes cutting out a whole section, because I know you've got some, I know Senator Simoneau has some, so everything is on the table. Next, please.
Amendment number 3 This is beginning on page 19 of the reprint, makes changes to the membership and charge of the Just Transition Working Group. Specifically, it alters the language regarding the members appointed by the presiding officers to say it should be 2 members of the Senate and 2 members of the House instead of just 1. It strikes the member or the representative of the Chesapeake Climate Action Network and instead adds a representative of the energy efficiency industry selected by the Secretary of the Environment. It specifies that the 2 representatives are registered apprenticeship sponsors. One should be selected by the Maryland chapter of the Associated Builders and Contractors, and one should be selected by the Baltimore, D.C. Metro Building and Construction Trades Council. And then it makes some changes to the charge of the working group, specifically on page 21 of the reprint. It adds that the working group should identify challenges and opportunities related to minimizing adverse employment and financial, we're missing an impacts there, on displaced workers and their communities through environmental policies conditioned on the fair distribution of cost and benefits, as well as study and identify resources necessary to protect workers from economic insecurity, including options for maintaining or supplementing retirement and health care benefits for dislocated workers affected by the downsizing of the fossil fuel industries.
Okay, so we're looking at the amendments that change the makeup of the commission. I had a request from one state senator who really wants to serve on it, and he thought we should just expand the number. And then I've added some language, also requested that they need to, this transition work group that's going to look at how our economy is going to shift over the next 5, 10, or 15 years, should look at a number of factors. It doesn't lock them into specific factors, but it adds a couple more. Discussion on the amendments on 19 through 21. Anybody object to those amendments? Okay, they're adopted. Next.
Amendment number 4, which begins on page 29 of the bill, or of the reprint, adds language from Senator Heddleman's bill, allowing schools and public safety buildings that, because of their location, are not eligible for certain transit and population density related LEED credits to earn a certified rather than a silver status under the LEED program.
You want to explain, if you can?
Sure. So, and again, this was something that was pulled in from a bill that Senator Heddleman has in our committee. The way, and this is the current requirement in state law, is that public schools and things that are capital projects that are fully funded with state funds have to be high performance buildings. That means that they have to, right now, they have to meet LEED Silver certification standards. The issue identified by Senator Heddleman was that the way the LEED program works is you get points for different sort of sustainability criteria. Some of those points that are available are based off of transit options and the availability of good public transit. And the density of development. Her argument was that if you're talking about a school or a public safety building, particularly in a rural area, you don't have an option where to put it. So you might be sort of penalized under the LEED system and not be able to get those points that could push you up into LEED Silver status, whereas the same exact building built in a more urban setting would be LEED Silver.
So rural locations are harmed because they can't show the urban transportation, which increases your LEED certification. Senator Hester.
I actually built our house to LEED Silver standards, and it was a lot of work, but a lot of fun. And so my question is, what is the point differential between silver and registered? Because we suffered because of that. We're rural, right? So we didn't get the density bonus or anything like that. But this is a long time ago now. There may be more. It may be like 10 points for that, but the difference between silver and registered may be broader. So it's just, I was just curious what kind of, if she wants it to be exactly even or she doesn't care.
I don't know. I don't know off the top of my head.
Okay. I support the idea. I think it may be generous.
Well, Senator, we're not going to finish it today.
Okay.
So let's
follow
move
up.
to adopt it. And if you come up with more information, obviously you can talk to Senator Hedelman or any expert. You can come back if you can give us more information or knowledge.
Okay.
Okay, the amendment on 29 and the objection, adopted. Next, please.
Amendment number 5, which is on page 32 of the reprint, limits the application of the zero-emission vehicle requirements for the state vehicle fleet to passenger cars rather than the broader term light-duty vehicles, and slows the phase-in of zero-emission vehicle purchase requirements. So you can... So it starts, it's on page 32. It's the bulk of this. So under this new phase-in, it would be at least 25% of passenger cars must be zero-emission vehicles in 2022 through 2024, 50% in 2025 and 2026, and then beginning in 2027, 100% of passenger cars would have to be zero-emission vehicles. Amendment also requires primary procurement units to make reasonable efforts to install charging equipment on state property under their control. And then later in the bill allows the Climate Solutions account established by the bill to be used to fund the installation of charging equipment.
If I can just speak to it very briefly, and then I'll call Senator Riley. I know he's got an amendment that's somewhat similar. I received testimony or a letter from DBM or DGS? DBM? DBM saying that they thought we should change the definitions to passenger car rather than light vehicle. I agreed, so we've adopted that. They wanted a slower implementation. I thought it was too slow, so I cut the baby, maybe not exactly in half, but I slowed it down some because, as we know, some agencies, you have to pull them kicking and screaming. So I've tried to do what I think is reasonable, but push them, because so far the administration, including MEA and other agencies, have been extremely slow, even though they've made promises. So I took about 70 or 75% of the recommended change from DBM. Senator.
Okay. Did they give you any information on how long the estimated life of these vehicles are normally depreciated before they're replaced?
Remember, I don't know if it's 3 years or 5 years on the traditional fleet.
April, if you're going to put that in your back of your mind, we want to make sure that we're not forcing cars off the road that still have a usable life, is my point.
Yeah, the bill is very explicit that when they have finished their lifetime and they are replaced.
Yeah, but we're also mandating percentage. Oh, so
no, it's percentage of the new one. So in other words,
I got it.
If 100 cars are retired because they hit their life cycle, let's say 5 years.
Right.
We're actually saying instead of buying 100 electric vehicles, we're saying in the first year you only have to replace 25 of them.
I got that.
So we are not affecting the life cycle.
I like this. This is good. But the point is, in 2026, 50% of the fleet will be projected to be electric, 25% gas.
No, it means
of the
that
new
cars
the
that
new
are
cars.
retired, they have to build up to 50% of them being electric. We are not retiring cars prematurely.
I got it. But in 2026, 50% of the newly purchased vehicles still may be gas, and I'm trying to figure out what the life expectancy is. And I'm sure they have a certain retirement age, either it's age, mileage, or a combination. So I'm just looking for more data. I like your amendment.
Yeah, at least, Senator. So in other words, if in the next 5 years the price comes down and they want to do more than 50%, look, I'm not happy that in 2026 or 2027, they potentially could buy half replacement cars that are on a gas engine. But I've acceded to some of their wishes of slowing it down.
Mr. Chairman. Thank you. I've been trying to get information, and it's flowing in like a waterfall. So when you were talking with the department on this, what was their reasoning, whether you agreed with it or not, of limiting it slower? Was it cost, or was it, I'm just trying to figure out.
They didn't call me. I got a letter, a 2-page letter, 3-page letter with a recommendation. I don't know.
They didn't explain why they wanted it that way?
I can't remember.
Okay. And then the other question is, changing it from light vehicle to passenger, is that because the light vehicles aren't available via electric, or what was the thought on that?
And again, this came from them.
Right.
They said light vehicles was a bigger universe. And I think they wanted a very explicit subsection of bolts or volts or whatever cars that are being used. They didn't want to be forced to change vans quite yet. So we have language here that says, besides passenger cars, they should make every effort to do other light vehicles, but we're not putting it on the timeline.
Okay, and just last thing. One of the issues I did hear when I talked to them was they had specialty vehicles, like on train tracks, that they put them on that. They would be exempt from going electric. Is that under this? Or it's coming?
So it's already, the bill is introduced, so page 32, lines 8 through 10. The section does not apply to the purchase of vehicles that have special performance requirements necessary for the protection and welfare of the public. That one's maybe a little bit different, but the passenger car, I think, that's really what the Department of Budget Management was saying. That's really, it's not even SUVs, it's not light duty trucks. Their argument was that the market right now, it's expanding in those other areas, but right now zero emission passenger cars are pretty widely available. The other ones are less so, particularly if you're looking for like a variety of options to price compare and things like that.
Amendments on page 32. Any objection to adopting those? Done. Next, please.
All right. Amendment number 6, this is on pages 36 through 37 of the bill. These amendments make clarifying changes to definitions related to zero-emission buses. These amendments were essentially, there were ones offered by Senator Zucker on his bill. They appear to be technical and clarifying.
Any objection to adopt? Any objection to adopting them?
Question, Mr. Chair. This is page 37, line 21,
36.
Right.
Amendment 6.
36, line 2.
Yeah, now go to the next line, 37, line 21. It's on the next page. It removes to a significant extent. It sounds like the original bill liked hybrid, and this is taking hybrid off the table.
I believe that would be my reading.
Okay, thank you very much. Just clarifying.
Okay.
Thank you.
Okay, any objection to these amendments on 36 and 37? Seeing none, we'll keep going.
Amendment number 7 on page 42 of the bill clarifies that the Department of Natural Resources may use money from the 2010 trust fund for certain forest management and forest buffer management activities.
That was suggested by someone in terms of vine removal and maintenance. Any objection to that? It's tree buffer management, which has been brought up. If no objection,
This is taking more money out of the Bay Restoration Fund?
this amendment doesn't. It's still, the money from the Bay Restoration Fund is capped. Yes.
This is from the 2010 Trust Fund, Chesapeake Bay 2010 Trust Fund.
But that fund is capped, so it's just allocating it to another area as well.
So the bill, right, takes 1.25 million from the fund and puts it towards these specific purposes.
Seeing no objection on 42. Adopted. Next. Repeat, Senator.
So just to be clear, that fund is administered through DNR, right, where the BRF is through MDE? Right. Okay.
Senator Washington.
So I just had a concern or a question about that funding source, and that it's used for the stormwater management and obligations. Is that it, or is that a different part of the bill? I'm sorry, I just want to make sure I have the funding source on that.
No, I don't believe the 2010 Trust Fund is used for
All right,
stormwater.
so
I believe
actually,
I think you're thinking of Bay
The Bay
Restoration
Restoration
Fund.
Thank you, thank you very much, I'll hold up.
Okay. Next, please.
Amendment number 8, which is on page 44 of the bill, alters the definition of underserved areas for purposes of the bill's tree planting provisions to include public housing projects located in urban areas.
Any discussion? Senator? Okay. Seeing no discussion, no objection, that's adopted. Next, please.
The last amendment is the one that just came around separately that Lemuria handed out. This is an amendment to the empower provisions in the bill.
What page is that on?
So this is the one that just came around separately. So it's where in the bill is it? Hold on a second.
The Vice Chair has pointed out it's on 28, line 22.
So this would provide for the energy conservation requirements that are applied to public utilities to ramp up over the next couple of years, rather than to take effect all at once.
We were in communications with PEPCO today. They suggested this. They thought the 3.0 ramp up was too high and too quick. So after extensive discussion, we adopted this amendment, and they say they will now support the bill. That's PEPCO. Any objection to this amendment? I'm sorry? Yep.
So they were gonna, the 3% was gonna be immediately, or is that, and then you're phasing it in now to 2027 to be 2.75?
Yes.
Okay.
Okay. Objection to that amendment? That's adopted. That's all of mine. Thank you, first of all, for your cooperation. And again, I tried to listen to Senator Carosa, some of the people, DBM, PEPCO, some adjustments. It's not, not everyone's loving it, but I tried to make things that more operable. Okay. You want to do some yours or whose?
So I actually have a revised version of this amendment that is coming around right now from Senator Gallion. This is amendment number 304-131/1. Amendment number 1.
Hold it. I don't have a copy of it.
Okay.
What page in the packet?
So this one's coming around separately.
Are these amendments drafted to this?
They're drafted to the bill. I can make them work with the amended bill. Right. Okay.
Thank you.
So amendment number 1 alters the greenhouse gas emissions reduction goals to require reductions of 50% instead of 60% by 2030 and the achievement of net zero emissions by 2050 instead of 2045.
Senator Gallion, you want to, well, first of all, it's got to be moved, be on the floor, moved and seconded. It's moved and seconded. Senator Gallion, you want to speak to it?
Thank you. This First Amendment was brought about because I talked with a Old Dominion Electric Co-op has the Wildcat Point facility in my district in Rising Sun. So I talked with them and to see how this legislation would affect their operation. And this is an operation that just opened up a couple years ago, and they're looking at I think it was like $1 billion investment in this, and it's natural gas. But they're supplying a lot of power. I forget the watts and all that. But anyhow, they're already, this company, I'm sure other companies are in similar boats where they've already have a goal of getting to zero by 2050, and the bill says 2045. And I asked the other day why we came with that 2045 number, and this is just simply asking to change that to 2050. These folks have borrowed a lot of money. I'm sure other companies have too, and a lot of these loans and such are 30 years. So if you built, say, in 2018, that'd be 30 years in the future. It'd be 2048, which would come after the year 2045 in the current legislation. And also with the page 8, line 28, that has the 50% instead of 60. Right now, my understanding is that goal is 40%, and honestly, I just felt like 60 was maybe a little too ambitious, and that 50 would be a better number. So that's why I just feel this amendment creates more realistic goals that these newer companies that are trying to do a good job can possibly live with.
Senator Carrozza.
Thank you, Mr. Chair. And I think I want to speak in support of the amendment and the realistic number, looking at 2050. And I just wanted to share with my colleagues, we can look at what's been going on in California and in Texas when if we do the energy transition too fast, we see what's gone on in those two states. We saw what happened with the weather in Texas, with putting so much, this headline says, "This blizzard exposes the perils of attempting to electrify everything." The point being that you need a balance. And what happened in Texas is if with this unexpected blizzard and storm, that those who actually had heat were those who were on natural gas. The point being not putting all of our eggs in one basket and to have a balanced approach. In California, there's an article, there's a lesson for the energy transition in California, and it talks about, again, the rolling blackouts and the fact that by having the goals so aggressive that the capacity wasn't there to meet the goals. So when you see situations, whether it's a state like California or a state like Texas, and then you look at, what is a reasonable amendment, moving it from 2045 to 2050, I think that's reasonable. And again, I think we can see that we don't want to go in the direction that a couple of these other states going too fast, too aggressive, and not having a balanced approach. So I would urge my colleagues to support the amendment.
Madam Vice Chair.
Mr. Chairman, I'm going to take the same two examples and come up with the exact opposite conclusion as our colleague from the Eastern Shore. California and Texas are two of the too many states that are actually totally surviving and barely surviving the impact of climate change. I don't know what the right answer is, Senator Gallion. I don't know whether 50 or 60%, I don't know, 2045, 2050, but unless we push, we're not going to get anywhere, and Maryland is could be in the next line of those with challenges. We've seen in Ellicott City, we've seen in Annapolis, we've seen the flooding, we've seen challenges as a result of climate challenges, and I think an aggressive and ambitious timetable with high standards is the only way we're going to make progress. And just remember, we're going to be back here every year. When it's not us, it'll be other people, and we always have the opportunity to modify if something becomes unrealistic and technology changes and makes it either easier or harder. So I am not going to support the amendment. I think we ought to really be pushing for this. Thank you.
O'Reilly.
Thank you very much. For you new people around here, we had a very vigorous debate on offshore wind with my good friend, Senator, and I'm going to use his name because he's not here anymore, E.J. Pipkin. And if you didn't know E.J. Pipkin, you're missing a massive guy with a great energy. And he and many of the Republicans, myself included, voted against the offshore wind because of the adverse economic impact to the ratepayer. But it passed. The General Assembly, in its wisdom, moved that project forward. About 4 years ago, Senator Hershey put in a bill to push the wind turbines farther offshore. Now, I got to tell you, it may be okay, but the problem is he did it after the company has spent billions of dollars in engineering and purchasing of equipment and staging stuff. I voted against Senator Hershey's bill because we were changing the rules after the horse was out of the gate. And this is the example that Senator Gallion brings up. I don't know if that's the right percentage or the right date, but I sure would like to find a way to grandfather projects that are either built in the past many years, 5 years or 10 years, or those that have been approved and are moving forward. I'm going to be supporting his concept. I'll be voting for these dates and percentages, but I think we need to find a way not to change the rules in the middle of the game. Thank you, Mr. Chairman.
To you, Senator Gallion.
Thank you, and thank you for that, Senator Riley. Just to kind of piggyback on that, you talk about the grandfather scenario, and I think that's important, but my understanding is if we change this year to 2050, that would take care of them, and that would kind of work like as that almost grandfather thing. I can't speak for every company. This is the only one in my district that I talk to, but what they do, and there was some talk about recent events in Texas and whatnot. This facility is 1,000 megawatt, supplies base loading energy, which is really important, as you know, with the grid, and we reflect on like what we're talking about in Texas, and it's needed for future electric grid reliability. And this, if you're trying to figure how much 1,000 megawatts does, it supplies enough energy now to keep the lights on for 390,000 homes. So it's important to point out as we try to make these improvements, and we're looking toward good environmental policy. You always got to keep in mind that when the lights go out, that what kind of effect does that have on the folks that are in those houses in cold weather? If you don't have a wood burning stove or whatnot. So I would rather err a little to the side of caution, but still, 50% is still better than the 40% that was in the old language. And 2050 is only 5 years past the 2045 year. So it's not like it's I think a huge ask that's putting us way out of line with the whole overall mission of the bill. Thank you.
Okay, I'm going to call on myself very briefly. Let me make 3 quick points. One of the problems in Texas is that natural gas lines froze. It wasn't simply solar panels were covered up by snow. natural gas lines froze, so it wasn't because of clean energy. That's number one. Number two, the 2045 date says net zero. That doesn't mean we're not going to use any other types of energy. But if, for example, you use geothermal or you use solar, everything is sort of balanced out. So you have puts and you have takes. So it doesn't mean that every energy plant is shut down. And finally, we have a sunset on those numbers. If people feel we can't make it, it's going to be back in front of this legislature to say it was too optimistic. Our eyes were bigger than our stomachs. So I think we have to be bold. Like the International Panel on Climate Change, thousands of scientists say, look, once we break 1.5 degrees Celsius, it's possible there's no coming back. That the Antarctic ice sheet and the Greenland ice sheet, once they start melting, you can't bring them back. So, I think this is a major problem. And I think if we don't have the urgency, there's never going to be the urgency. So that's why I would also recommend voting against the amendment. Roll call on the amendment, on the Gallion amendment. Yeah, sure.
Is this subject matter, is this typically with the greenhouse gases, is that typically finance dealing with energy?
Climate bill of 2009 and 2016 came through our committee.
Okay. All right. So I have to tell you, I'm not sure what the impact of his or the impact of yours, whether it's 50 or 60%. And obviously, we don't live in a vacuum. Ideally, in the real world, we'd like to do this federally or globally. So can you just share a little how you came up with the 60%, other than we got to do quicker and do better because things are going to fall apart? But what real impact are we talking, difference between 50 and 60 or 40 and 60? What are the real life impacts to our energy, to our consumers? Do we have any idea how this is going to impact the state and the people in it?
Well, not fully, but let me just give you an example. The Department of the Environment, up until 4 months ago, said we should be reducing greenhouse gas at 40%. And then 4 or 5 months ago, I can't remember the date, they said, we have to move more rapidly. One, they thought we were going to accomplish 40%, but that we had to do more. So, and that's just an example where even the Department of the Environment, working under the Hogan administration, saw it as a moving number. And, this is 60% from, I think, 2006. I can't remember the baseline year. But a lot of it is driven by what international scientists say we have to do. So, I can't tell you it's perfect. It's, whether it's, we call it it calls for economic study. I want to do all that stuff. But we have to look ahead. I don't want to be dramatic, but that whole question of, our children or grandchildren saying, when there's flooding and people are starving, what do you do to stop this? And I think this bill is trying to take a step in that direction.
Just so I understand the bill, if we implement the bill as amended, is that going to get us to 60%, or is that going to get us above 60%?
It doesn't lay all of these strategies. It lays some strategies. It's still going to require the Department of the Environment to come up with other strategies. You see, ladies and gentlemen, and not to get into like a lecture here, we have reduced greenhouse gas in the last 6 years. But the main reason we've reduced it is coal has gotten expensive and oil's gotten expensive, and there's been a shift to natural gas, which is cheaper, and it emits less. So the market has driven some of our greenhouse gas reductions, and obviously in the past year, transportation with cars has also been a benefit. So I'm not sure, I don't want to say we're past the low-hanging fruit, but if we're going to start making changes, we're going to have to adopt some other practices. The strategies I put in here are some. They are not the sum total. And I expect the department, who is now 13 months late in the plan they were required to give the legislature, that they will come up with other strategies.
Okay, so again, I'm really trying to understand the bill. So if they implement what's in this bill, it'll get us somewhere closer to 60, and then the department will have to come up within their plan how to get to the rest of the 60.
Yep.
Just one brief question. Thank you, Mr. Chair. You served on the Climate Change Commission. I just was curious, what year did that commission propose in their report and recommendations? Which did they propose 2060?
No, first of all, they have not done a final plan yet. They have not proposed a final plan yet, but in November, December, I don't remember, what was 40% in law, they said, you know what, maybe we have to be more aggressive. And they were suggesting 50, but I don't know if that's been adopted anywhere.
So that is actually in line with my amendment that fit what they're talking about, 50%.
Right, but one of the problems and why we have this bill in front of us is we've been wasting time the last 5 years. And we have not done what we should be doing. And they're late 13 months on a plan to get us out of this morass or move us in the right direction. I don't feel confident with their strategies. I mean, and I have to tell you, their first draft did not list any concrete actions. It said, we should deal with transportation. That to me isn't a strategy. So I just don't have confidence in the recommendations.
Fair enough.
Okay, roll call. On the Gallion amendment to change 60 to 50 and 245 to 2050. Okay, the amendment receives 4, 7 against, it dies.
Amendment number 2 from Senator Gallion strikes language prohibiting the use of highway widening or additional road construction as an emission reduction measure in the state's greenhouse gas emission reduction plan.
Are these pages right? Page 16?
Yes, yeah, the page is right.
Let's make sure the amendment's moved and seconded. Is there a second for the Riley, Senator Riley? Yes, Senator Gallion.
So, and I know there's going to be obviously different viewpoints on this, and we'll disagree agreeably on it. But you know, I look at road. You know, if you could keep traffic moving, I think that's a good thing because it's the start and the stops that are going to emit the main problems here as far as emissions, as far as to my understanding. So that's one point with the widening. And another thing. You know, I don't necessarily buy the argument that just because you widen roads that you're going to have more cars flock to it. I think in this current day with the COVID-19 pandemic, a lot of folks have started and transitioned working from home. And I think that's a trend that possibly will continue when folks don't have to live necessarily near where they work. They can live a little farther away. They're not going to have to commute. And I think the world has changed because of that. So honestly, I don't see it necessary to take that out. I think, you know, in my opinion, it's a positive thing. Thank you.
Speaking strongly against this amendment, sorry, Senator Gallion, as we debate the widening of I-270 and I-495, as there have been studies, as there were studies for the construction of the intercounty connector, there is data that shows that if you build it, they will come. And that people say, oh, I can get to work faster, so rather than taking Metro, I'll just jump in my car. And sure enough, the new roads, the new lanes get crowded. So I agree with the concept of what you said, Senator Gallion, about the world has changed, and I do think telecommuting will be used more, in which case there won't even be a demand for highway widening. So I think both, because I'm not sure that there will exist, and if the highway widening does happen, I think it completely contravenes our hope and intention, because I don't think it will result in faster traffic and a solution to carbon emissions. I oppose the amendment.
Thank you very much, Mr. Chairman. I'm going to be supporting the amendment. We have seen at the Bay Bridge, at the Virginia 95 area, the additional pavement doesn't have to be stagnant in one direction. Creating additional lanes that are reversible make an awful lot of sense to me. This removes that option off the table. I think it should be still on the table. We should still look at it. So I'll be supporting the amendment.
Yeah, this, I'm going to call myself, this doesn't prohibit it. It just says it can't be used in counting greenhouse gas reduction in their plan. If we want to have reversible roads or even build additional lanes, that can continue. It just says, look, in the plan that they developed last fall, they actually, I would say, had the temerity to say that road widening was going to reduce greenhouse gases by something, 0.5%, 1%, something. And this was in the midst, maybe it was a year and a half ago, where there was a recommendation to expand 270 and the Beltway pre-pandemic. And I happen to agree with the vice chair. If you add lanes, it's going to generally bring more cars. And I thought that was silly. But Senator Gallion, I hope what you said is true, that fewer people use their automobiles. But if fewer people use their automobiles, as the vice chair said, you don't need to widen lanes. But I haven't heard from the governor, for example, and this could be the next governor too, about reassessing and not expanding 270 and the Beltway and the bridge. So I just think most studies have shown that if you add 2 lanes or 4 lanes or 6 lanes, while some cars are not going to idle, and that's going to save this much, the addition of cars on the wider roads is going to have this much more emissions. That's the only reason I've included that in the bill. Okay. Well, those who will favor the amendment, raise your hand. I see 4. Those that will oppose, similarly. Okay. The vote is 4-7 in opposition to the amendment. Next.
Amendment number 3 strikes language prohibiting the use of carbon capture storage technology as emission reduction measures in the state plan.
Please.
Thank you. We briefly discussed this a little bit earlier with the chairman's one amendment that talks about the science kind of still allowing this, but I would just like that to be a little clearer. I think maybe that amendment would be a little more subjective. This would be a little more crystallized. So the purpose of this amendment is to authorize the inclusion of carbon capture, utilization, and storage, clearly, CCUS is abbreviated. As I mentioned, the amendment we passed did kind of give a little leeway for this, but my understanding is for MDE to create a plan to reach net zero emissions by 2045 will be difficult, if not impossible, without this technology being on the table. This is a view gaining global recognition where even at the Intergovernmental Panel on Climate Change, the IPCC, 3 of their 4 projected pathways, this was done in 2018, for carbon reduction rely on some form of carbon capture technologies. This is a key developing technology in the fight against climate change. Furthermore, there's a good chance the state cannot even begin to decarbonize the industrial sector without this technology. If net zero carbon is the goal, it is inconceivable that CCUS is omitted from state policy. We just want to make this totally clear, and this really, I think, clarifies that part, that line 7-8, to get rid of that. And just want to mention Bill Gates is very heavily invested in this technology, and it's going to take a lot of research and development, but why wouldn't we clearly have all these options on the table? Because going forward, technology changes, and new technologies are coming about all the time, potentially. So let's clearly leave this option on the table, and I would encourage my fellow committee members to accept this amendment. Thank you.
I'm sorry, Senator Carrozza.
Thank you, Mr. Chair, and I'm speaking in strong support of the amendment. And I realize that your amendment, Mr. Chair, addressed some of the carbon capture, but it still says it may not use carbon capture, and then puts the onus on having to prove that that you can use it. And just to share with my colleagues, carbon capture, utilization, and storage, CCUS, that's for you, Madam Vice Chair, is the only technology that can deliver deep emissions reductions in hard-to-abate industrial sectors such as steel, fertilizer, and cement factories. And this technology does support the power transition to renewables. So again, why would we take away one of our options or make it so difficult to use this option? And so again, this bill, we're trying to put some language and amendments in there so that these goals are actually achievable, and being realistic about it. So, I support the amendment. I believe it gives us an option, and I believe it puts us on a course for more realistic attainment to the goals that are proposed in this bill.
Senator, look, if you don't like that it says may not be used, we could change it to say may be used, carbon capture may be used, if it's based on technology that's proven and achieves carbon reductions. I put this in because there have been a lot of faux efforts. It happened with coal. You saw the advertisements for 4 years about clean coal. There is no clean coal. And they didn't want that to happen with carbon capture. With this amendment, and again, if you want to say NDE has to prove it's verifiable, I don't care. This is essentially putting it back in. And it was suggested to me that it was too abrupt to say you can't use it. This says you can use it as long as it's verifiable. I mean, don't you want a carbon capture to be verifiable and quantifiable? I mean, I don't know. Senator Frey-Hester.
I was just going to ask, I support your previous amendment, Chair, and I was just curious with legal counsel, what does scientifically proven in this case mean?
Science or data backing it up. The language is vague. It would be up to MDE to determine what it means.
Okay, thank you very much.
You offered to at least change that to may, so it's a little bit more clear. I think when you see a may not, you immediately kind of revert to the may not. And if you're saying you would consider that just saying may, along with the other language you provided, I think that gives it a little bit more of an option. I defer to the amendment sponsor, but I thought, to me, when I see a may not, I'm first thinking, you really have to go through the hoops to show that you can actually do something. And if this is going to say you may use it with the qualifications, perhaps that puts us on a better track.
I'm happy to accept that. Should we do that after we vote on his amendment or in place of his amendment? Okay. The motion is to remove that section totally. So, yeah, totally. Those who'll be voting for the Gallion amendment signify by raising your hand. Those opposed? It goes down. I will consider that as a friendly amendment, Senator. So I don't have the language in front of me, but I trust it'll come out of that section. We'll do a separate section that'll say it may be used with the existing, with that new language. Okay. It's a minute to 7. I said we'd have a hard stop at 7. Yeah, I guess we should just stop there. Okay. And, I want to thank everybody, and committee council has the other amendments. We have a bunch more to go through. We'll do that on Friday. And thank you for your work today. Okay.
Can I just ask for Friday, would it be helpful? I'm assuming we should do a whole new packet for this rather than, and that way we can have the amendments that are loose right now together. So anything we haven't gotten to yet will be in a new packet.
That's fine.
Okay.
We trust committee council. Okay, thank you. We're adjourned. Get some dinner, get some rest.